mucho, pero bueno, ¿me puedes cerrar esa puerta?
Good afternoon and welcome to, on behalf of IWIRC and III, to Treasure Hunt, Clues for a Successful Bankruptcy and Asset Recovery Case. On behalf of IWIRC and III, my name is Jenny Cudahy. I am on the IWIRC staff. We are having to shuffle a little bit. We've had some internet issues, but we are ready to go and excited about a wonderful session for you. We just want to remind you that the materials for this session are at the bottom of the screen. You can click if you scroll down, you can see the materials. We will be posting CLE and CPE codes in the attendee chat function, and that function is in the upper right-hand corner of your screen. All CLE and CPE instructions, as well as a brief survey, will be emailed to you after the last session on March 8th. All sessions are being recorded and will be posted on the IWIRC YouTube channel in the next 2 weeks. Pending time constraints, you are welcome to ask any questions in that chat function, and we will pose them to the moderators. Panelists will not be able to see the questions, but we will make sure that they get them. So just type them into that chat function, and we will make sure that panelists have them and are able to respond. I am going to turn this session over to our moderator now, Aimee Prieto from the Dominican Republic. Aimee, welcome, and we're so glad you all are here. Thank you.
Thank you very much. Welcome to our panel, Treasure Hunt, Clues for a Successful Bankruptcy and Asset Recovery Case. My name is Aimee Prieto. I have been a lawyer in the Dominican Republic for 20 years. The Dominican Republic is a great location to invest due to the warm weather and pristine beaches. The transactional side of my practice assists businesses and individuals to invest in our country. However, among the legitimate investors, we also find some shady characters. The litigation side of my practice assists fraud victims to recover assets that the fraudster invests in the Dominican Republic. I am the only Dominican lawyer who is a certified fraud examiner, CFE. It is my pleasure to moderate this panel with 5 well-known specialists from different jurisdictions. These are Nyana, Rosa, would you introduce yourself?
Yeah, sure. Hello, everyone. My name is Rosa. I'm a Mexican lawyer, and I'm from Juarez, Mexico, the border with El Paso, Texas, which gives me a bicultural background because I was raised and I spent half of my childhood and adolescence in El Paso, Texas. But then I moved to Mexico City to law school, and I became a transactional lawyer in a large firm dealing with cross-border financing. And then I was invited to join the Supreme Court. Justice had a securitization case on taxes, and they needed someone to assist in the technical matter. So I was hired, and I stayed there for many years, helping them studying the provisions of business law, bankruptcy law, and civil law to see if they were in agreement with the Constitution. Finally, I'm combining my practice with teaching and doing research in insolvency. I have a goal to contribute in the development of insolvency law in Mexico. Thank you, Aimee.
Thank you, Rosa. Nyana.
Hi, hello everyone. My name is Nyana Miller. I am a lawyer in Miami, Florida. And well, when I introduce myself, it's easier to explain who I am by saying that I'm the product of the US government's project to create peace in the world. So my father was one of the first of the US Peace Corps volunteers in Brazil, and my mother was one of the Brazilians recruited to teach Portuguese to said Peace Corps volunteers. And so the result of this naturally is a cross-border insolvency lawyer, right? So today I, in my practice, mostly help foreign clients, a lot of foreign trustees from other jurisdictions who want to come to the United States to pursue evidence or to pursue assets of the debtor. So I work frequently in an asset recovery kind of context. I also handle judgment enforcement, usually foreign as in non-American judgments that are being enforced in the United States, and general civil litigation. I also have the great privilege of serving as IWIRC's Latin America Regional Director.
Thank you, Nyana. Susana, would you introduce yourself?
Thank you, Aimee, and thank you to the IIII and IWIRC for this amazing event. I am Susana Hidvegi. I am the Superintendent of Bankruptcy in Colombia. And I believe that I'm very fortunate to have a 360-degree vision on insolvency. In fact, until a couple of years ago, I was the head of the bankruptcy practice of a top-tier law firm in Colombia, where I engaged in the private practice of insolvency and restructuring and participated in the most relevant cases and every cross-border insolvency case pursued at that time. Also, I have been teaching bankruptcy for more than 10 years now, and I currently represent the Republic of Colombia in the Group 5 of UNCITRAL in a diplomatic role. But my main role right now is to be the chief bankruptcy judge of the entire country of Colombia. But due to the COVID-19 crisis, I had the wonderful opportunity to participate in the drafting of the new bankruptcy law that was issued to face the emergency. Thus, I have the chance not only to be in both sides of the bar, but also to participate in the regulation and the academic environment. I trust this background allows me to understand insolvency from the different perspectives and, as I said, as a 360-degree vision and to contribute to the development of this field. I hope this will allow me to contribute to the panel. Thank you.
Thank you, Susana. Pamela, it's a lawyer from Chile.
Hi, hi, Aimee, and thanks to all the attendants, especially to IWIRC and AAA for the opportunity of being here and have such a nice conversation. Well, I feel also very lucky of being an insolvency lawyer. You know why? I was just talking to one of my daughters about why I decided to be a lawyer. And I explained to her that I could combine two of my passions. I love numbers and letters, like reading and all about numbers. And I doubt about studying law. And in my third grade, when I was studying there, I was invited to join the insolvency superintendents. And it has been 30 years since that day. And until now, I feel lucky to be involved in this field, advising creditors, debtors, and even trustees. I was also lucky to represent the first Chilean trustee that was recognized abroad in a cross-border case. Was just the first year where our law was enacted and included the model law. So in that case, the foreign trustee was recognized and we were able to recover assets in more than 8 different. Thank you.
Thank you, Pamela. Pamela is also the co-chair for the Latin America chapter for IWIRC.
Thank you, Aimee.
Marlyn.
Thank you for joining us today. I'm Marlyn Narkis. I'm a partner at the law firm MDU Legal in the Republic of Panama. I want to tell you a little about me. I come from a merchant's family. And since I was little, my siblings and my cousins had to go to work at the family stores, and the main subject of all our conversations in family dinners were always about business. So they continued to be merchants, and I decided to become an attorney. And this exposure, I feel that has the exposure to this business mentality has helped me be a partner to my clients in procuring their goals and understand their mindset when having to resolve their legal matters. So I'm very glad to have that experience and be able to join that with my legal experience.
Thank you all. As you can see, we have very experienced panelists today. In the best case scenario, bankruptcy, it's an opportunity for the honest debtor to receive a fresh start and to rehabilitate businesses in financial distress. In the worst case scenario, bankruptcy reveals a situation involving misconduct, such as self-dealing, asset stripping, over-invoicing, and fraudulent transfers. In our increasingly global world, such misconduct may involve a complex structure of offshore companies spanning several jurisdictions. Some may just throw their hands up in despair rather than attempt to untangle such a complex mess. However, the practitioners on this panel do not shy away from the challenges presented by this complex scheme to conceal assets. Instead, we embrace the challenge of a good treasure hunt. Legal and financial professionals who seek to pick up the trail of diverted corporate assets need to think creatively about the tools available in the legal systems where those assets were or are held. Such professionals increasingly find that insolvency laws provide unique and powerful tools to get inside the company that was used to perpetrate the fraud, to get access to valuable information about the company and its financial affairs, and ultimately bring assets into the States so that they can be administered for the benefit of creditors. To showcase these tools, we have developed a hypothetical case regarding the Willy Wonka chocolate factory. Sound familiar, right? This was a global chocolate empire valued at over $500 million US. The company had facilities in the US, Mexico, Colombia, and Chile. Although its credit rating had declined a bit in recent years, investors and creditors believed that the company had a strong brand and a very dedicated workforce of Oompa Loompas. For purposes of today's discussions, we will not focus on the details of the company's decline into bankruptcy. Suffice it to say that someone has his hand in the cookie jar. Although the process of putting a company into bankruptcy is itself an interesting topic, today we want to focus on what happens after the case begins and on what tools are available across each of the jurisdictions. So, we will assume that the US company is in Chapter 7 liquidation in the US. The trustee's review of the company's records reveals that the Mexican subsidiaries' manufacturing facilities were transferred to third parties shortly before bankruptcy. The trustee suspects that these transfers were made without fair market consideration and to recently incorporated companies, possibly controlled by insiders. Happily, we have Nyana Miller on hand to help us with this. Nyana, the trustee comes to you at a loss. The company has minimal records regarding the transactions, which is by itself highly suspicious. And neither the debtors nor the subsidiaries' accounts show receipt of consideration for these transfers. How can you help the trustee to discover the details of these transactions?
Thank you, Aimee. These are all very relevant questions. And of course, you know, the trustee may feel frustrated by the lack of records, but that's exactly where we need to start. So the first step, of course, is to review what records are available to the trustee, particularly, you know, account statements, the books and records of the company. All of those kinds of records will at least, you know, give us a starting place. But the trustee in the United States has very powerful discovery tools for situations where the debtor has not produced everything that perhaps they should have, and where the debtor's financial dealings are unclear. So the relevant rule is called Rule 2004, and that permits the trustee and other parties in interest, actually, but here it's relevant that it's the trustee. It permits the trustee to obtain documents and testimony relating to the acts, conduct, property, liabilities, and financial condition of the debtor. So that's a very broad scope. Oh, and it also includes any matter which may affect the administration of the debtor's estate. That's far broader than the discovery that we get in regular civil litigation in the United States. And it's also relevant that the trustee can require this production by issuing subpoenas. And I believe that's different than for you know, most of the countries in Latin America, in the sense that the trustee's own attorneys, and not the courts in most states, at least, in most districts in the United States, it's the attorneys that fill out the subpoena, list all of the documents that should be produced in accordance with the rule, and then send the subpoena by private process server to the party that needs to respond. And who are those parties? They, you know, we've already exhausted the debtor, right? The presumption is that the debtor's records are now the trustee's records. So we need to go to third parties. We can go to third parties such as banks, such as accountants and attorneys. Here, the banks that were involved in the transaction itself, if there was financing, you know, I'd want to request a copy of the due diligence package, the closing documents, obviously the actual wire transfers showing any purchase price paid, so long as that price, you know, or that amount of money passed through a US bank account, I should be able to get those records, even if they weren't provided in the first instance by the trustee. So we can go directly to the banks with those kind of subpoenas. We can also go to outside accountants who were involved in the transaction, or who are generally involved in preparing tax returns, or you know, helping the debtor to keep track of its books. And also, you know, in this case, I would look to the attorneys that were involved in that transaction. So perhaps the debtor didn't keep good records, but the records could be located in someone's office. So I would want any agreements, drafts of those documents, instructions to local counsel. Obviously, these subsidiaries are in other jurisdictions, so there should be foreign counsel that were involved. And of course, I would want any instructions relating to funds. And so our subpoenas in the United States tend to be very specific. We can list all of the specific types and categories of documents and the subject matter of the documents that we want to receive from parties. And the other thing that is important is that we can send those subpoenas to anyone in the United States. So it doesn't have to be in the same district where the bankruptcy court sits. It can be in a different district. It can be all the way up in Alaska if we want. And one thing that is relevant here is that we're dealing with subsidiaries. So those subsidiaries are property of the debtor. And if you remember what I talked about at the beginning, the scope is very broad. It includes anything that is property or to a liability of the debtor. So we can definitely ask very specific questions about these subsidiaries. However, the trustee also has been asking about Willy Wonka. The debtor's majority shareholder, the trustee thinks he's a really shady dude. He must be hiding something. Have you guys seen that movie? He's really shady. And the trustee wants to know if we can take discovery about the assets of the debtor's shareholders. So on that one, I'd have to say not so fast. Rule 2004 clearly allows forward tracing. So if I can find specific transactions going from the debtor, from the company to the shareholder, I can definitely take more discovery about those transactions that I find, and to discover the ultimate end location of those transfers, right? Whether it's money or whether it's actual, some other sort of property of the debtor that was transferred to a shareholder or to his family members or something else or to some Oompa Loompa, we can trace going forward. But to go back to the shareholder and just say, I want to know all of your financial wherewithal, I want to, do backwards tracing. It's called backwards tracing when you start with the target of the investigation, right? You want to start with the shady guy. We generally cannot do that. We can't do that as a starting place. So one thing that is helpful in these kind of cases is to involve a forensic accountant who may be able to help us to trace monies or to trace other transactions involving both the debtor and benefiting the shareholder, or showing improper commingling of funds between the debtor and the shareholder. So that kind of evidence may help me to broaden the amount of information that I can request in the future about the shareholder. And the last thing I can do is to depose the shareholder and ask him about his dealings with the debtor. There's no problem with that, with sitting him down. A deposition, by the way, for those maybe who are not US licensed attorneys, a deposition in the United States is like a private questioning. So there's no judge present, that you sit in front of a court reporter who takes down word for word everything that is said, and the attorneys get to ask questions of the person, the witness, who is being deposed. So those are the tools that we have, Aimee. I think they are pretty strong. We can certainly find evidence, whatever evidence is available in the United States, whether in the hands of the debtor or in the hands of third parties, to follow up on these claims.
Thank you, Nyana. I wonder, how does Rule 2004 discovery compare to discovery that is available to a creditor of a company that is not in bankruptcy?
That's a great question. So Rule 2004 discovery is broader than what you would get in ordinary civil litigation. It's arguably similar in scope to what you would get in post-judgment discovery. So if the creditor had already sued for failure to pay on a note, for example, and gotten a judgment and was in pursuit of executing on assets of the debtor, it would be approximately similar. But the other limitation that you find, particularly with state court judgments in the United States, is that you still are tied to your local jurisdiction where you obtained the judgment. However, in bankruptcy, we are not. So in bankruptcy, I immediately have access to the broadest form of discovery, similar to post-judgment discovery, and I immediately have nationwide jurisdiction to issue subpoenas anywhere in the country.
Thank you very much, Nyana. It's good to have you.
Thanks, Aimee.
Now we are crossing the border from the US to Mexico. Willy Wonka's chocolate factory has a Mexican subsidiary with manufacturing facilities in many cities of Mexico, which apparently were transferred to third parties shortly before Chapter 7 was filed in the US. The trustee is looking for legal advice and luckily has Rosa about what measures are available under Mexican law to unwind those transfers or otherwise generate value for the Chapter 7 estate from the sale of those assets. So Rosa, what type of measures could be requested in bankruptcy?
Okay, Aimee. There are different types of measures. I mean, there are measures outside of bankruptcy and within bankruptcy. In this case, as you have explained, the US debtor has been declared bankrupt. It's in liquidation in a Chapter 7 case. So if this debtor wants information, from the Mexican subsidiary, Mexico has adopted the model law, and it would be possible to cooperate. The trustee in this Chapter 7 case can come to approach a Mexican court and request recognition of the Chapter 7 case. Here, we would need to think that if the US case, the Chapter 7 case, only involves the US debtor, or if it also involves a Mexican subsidiary. There have been many cases of recognition of main foreign proceedings in Mexico, where this foreign debtor only had assets in Mexico. It didn't have a Mexican subsidiary. In this case, we know it has a Mexican subsidiary. So maybe what we should check is if this Mexican subsidiary is also insolvent. Mexican law provides for a test for to determine if a company is insolvent, and it basically is that 35% of its obligations would have to be overdue for 30 days at least, or this debtor doesn't have enough liquidity to pay up to 80% of its obligations. So it's a high test. If this debtor meets this test, well, then we can start a Mexican insolvency proceeding, and this would make much easier the cooperation between courts. Now, since the moment this trustee in the US case approaches the Mexican court, it has standing to request many measures. Measures are broader within a bankruptcy proceeding than out of a bankruptcy proceeding. Since the filing, this petition for recognition, the debtor to request a stay, forbiddance of sale of the assets. Remember, we are in a case where it's a liquidation. This is not a case where we're looking for a reorganization of the company or to try to rescue the company, but we're looking for the assets. So the trustee may ask the Mexican court for many measures. Also, there's an express provision in the Mexican bankruptcy law that allows this trustee to request information. It's similar to the discovery in the US. The trustee could ask for information on the books, records, business, liabilities, and rights of this debtor. So this can be a very useful tool. Within the bankruptcy proceeding, there's a clawback action that may go up to 3 years, and it unwinds transactions at undervalue or for no consideration within this period, before the debtor is declared insolvent. Now, if we are speaking of measures outside of bankruptcy, well, I must say they're not so common in Mexico. However, to help Nyana, I made a meticulous revision of our procedural laws. And let me tell you that there are many features that I think we could use in this specific case to try to locate the assets, even if we do not start the bankruptcy proceeding of the Mexican subsidiary. Our laws provide that we could compel testimony, and the testimony could be of people connected with the company. This could even be the shareholder, shareholders of the company. Also, you can ask for the judge for an order to request that this shareholder or officers of the company do not leave the country without leaving a legal representative and enough expenses to cover, the process and the results of the process. So we could make sure, we would try to make sure, we can get of the shareholders, and also to request the court measures to find information about the assets and the books and records of the company. Well, I will stop here, and maybe if you have follow-up questions more ahead, I'll be happy to answer them.
Thank you, Rosa. I think you have clearly stated that you have broader measures in bankruptcy than out of bankruptcy. And out of bankruptcy, there are creative ways of getting additional protections for the asset. So, Susana, Willy Wonka's Colombian subsidiary owned plantations in Santander, Colombia. 2 of such plantations were apparently transferred to a third party approximately 9 months before the beginning of the US Chapter 7 case. What measures are available in Colombia to unwind these transfers and to bring value to the state?
Thank you, Aimee. So first, I would talk about a little bit of tools that are outside of bankruptcy that could be used. We also have Acción Pauliana, as mentioned in Mexico. This is basically a civil law clawback. It must be pursued before the civil courts, which can take several years because the decision could be subject to appeal, and even in some cases could be brought for revision before the Supreme Court of Justice. So for this action, there are some elements that must be met. The transaction must be over the debtor's assets. The debtor's state must be insufficient to pay all the creditors, and there must be fraud. This means that there must be an agreement between the parties to commit fraud. This action is not very common, so I will move to the actions in bankruptcy. So it would be possible to file first a bankruptcy petition under the local law, but this supposes that some objective requirements are met, such as the debtor is in insolvency, which means that it must have at least 2 obligations in default for at least 90 days that represent of the external liabilities. So if this proceeding is commenced a local liquidation, then there is a clawback under the bankruptcy law. This clawback, it's a 74 clawback action and must meet also some requirements. The act must have affected the bankruptcy state. In this case, we are talking about the plantations that were taken away from the company. Also, the bankruptcy state must be insufficient to pay all the claims. And the act must have been done before or during the applicable preferential period, which is 18 months before the commencement of the insolvency proceeding. In this case, we're talking about nine months before the Chapter 7, so probably sometime after the local proceeding is commenced. So probably this will be in the look period. So the parties to the transaction must show that it was done in good faith. So probably this would be easier to pursue instead of the just the civil law action. Aimee.
Thank you, Susana. And what measures are available in Colombia to obtain necessary information, such as the purchase agreement or documents showing whether a purchase price for a certain property was actually paid by the purchaser? Okay, again, I'm gonna speak in bankruptcy and out of bankruptcy. So out of bankruptcy, first, real estate must be transferred with a public deed. So this is recorded in the public records. So first, it would be key to check in the public records, but if there's any kind of fraud, probably the public records won't show it. So it is also possible to go to a civil court to obtain something we call out-of-court production of evidence for future litigation. So you just go to the civil court. There's no need to have a current litigation. You just go to the court to obtain the evidence that you need. So you can request the court to order disclosure of information. You can even request that the judge, through its officers, visits the entity and requests the information inside. And also the court may order depositions of the relevant parties. So this information may then be used in future litigation before the competent authority. Now, in bankruptcy, there is a principle in the bankruptcy law that it's called information principle, pursuant to which all the parties must provide accurate information and must keep it available during the proceeding. So in a local liquidation, the trustee or liquidator appointed will collect all the accounting books
all the information available in the debtor's hand. And also the judge may order the production of additional evidence, the disclosure of information, or even, as I mentioned in the out-of-court production, the judge may visit the facilities and the entity and request all the information that is in sight and order depositions and other evidence that may be required. And finally, I will just mention that in cross-border insolvency, if the case is done in the US, just the Chapter 7, and brought for recognition to Colombia, the foreign representative here will be the trustee, may request the Colombian court to question witnesses, to produce evidence about the assets, the business, the rights, and the liabilities of the debtor. So I think with that, you may obtain the information here in the country.
Susana, the first proceeding that you mentioned, the one out of bankruptcy to obtain evidence, is that an administrative procedure, is contentious, or?
It is judicial because it's before the civil courts, but there is no actual litigation. You just have to tell the court, I need this evidence to preserve it because it's likely, for instance, that the counterparty is going to destroy it. So let's assume that we are not in a bankruptcy situation, but rather in an antitrust case. You can still go to civil courts and ask for this anticipated evidence production to keep it for future litigation. So if you get a deposition that you can use it in a future proceeding, that will be done before a court, so it has value as proof. That's the value of those kind of evidence. We don't have depositions as they have it in the US, where it is private between the parties. So here we always involve a judge. It's something similar, but with the judge there.
The judge present. Oh, yeah. Thank you, Susana. Let's move on to Chile. Pamela, the chocolate factory has its distribution center in Chile. This one did not get fraudulently transferred, but the manager of the Chilean distributor says that she will not take orders from a bankruptcy trustee in a foreign country. So she's looking for guidance on what do you recommend, how to take control of this Chilean asset so that it can be administered for the benefit of the Chapter 7 estate. Should the US insolvency proceeding be recognized in Chile? How should the trustee proceed?
Pamela, you're on mute.
Sorry again. Thanks, Aimee. And this is such an exciting challenge and question because in this case, we have a company which is running its business and having profits. So what should we do now? So first of all, I will explain a general background about our insolvency law, which was enacted in 2014. And our law includes reorganization, restructuring, liquidation of either individuals and companies. And also there's a whole special chapter which includes most of the regulation suggested by the model law of UNCITRAL regarding cross-border insolvency. So that's important to keep in mind. So we understand that this distribution center is doing great. So it provides with important profit to their holding company. So I will invite you, to apply here a strategic analysis and review, combining our internal regulations and looking forward to obtain the best outcome for the creditors in each of the countries where they are located. So my question is, what should be better for paying all the creditors? Should we recognize the foreign trustee in Chile, or do we need, it's better to do something else? Especially bearing in mind that, as you mentioned, Aimee, the Chilean administration is telling why I should receive instructions from a foreign representative. It doesn't have any link with me. So in Chile, we don't have a lot of experience. So there's a lot of, we apply directly the rule on regard to recognitions of foreign trustees in a scenario of liquidation, which is equivalent to Chapter 7. We have some experience regarding Chapter 11, but not Chapter 7. So that's the first issue. There were 3 filings in that regard, and no one was successful. But continue with our strategic analysis. I would suggest our client that in this case, it's better to appoint, and that the Chilean subsidiary, the distribution center, will file for their restructuring instead of recognizing the foreign trustee. The key issue here is that in that case, if you follow my suggestion, that Chilean trustee could be requested by the debtor itself and be approved with the votes of the creditors, and can be in direct coordination as a team with the foreign trustee. That's the key issue. So why? I will explain that as well. Because even though we recognize the foreign trustee in Chile, creditors have always the right to initiate a new proceeding in Chile. So you can have a scenario where 2 proceedings will take place at the same time with a foreign trustee recognized and a Chilean trustee appointed. So it's going to be a big problem, a lot of costs, and no coordination at all. So if you follow this strategy, and there will be a coordination between the Chilean trustee and the foreign representative, the foreign trustee in this case, you can change the administration of the company. You can check with all the financial statement and balance sheet and everything to check what is the accounting situation of the company, if all the assets are still in the company. If not, you can file for the clawback actions. But in this case, coordination and make a very good team, it's better than recognizing the foreign trustee, 100%.
Thank you, Pamela.
Yeah.
So the takeaway, coordination is better than going to court. Marlyn, we have seen some clues pointing to Panama. The trustee has discovered that the buyers of the plantations are all controlled by a Panamanian company. The trustee in the US has requested information about the shareholders and final beneficiaries of the Panamanian company. What measures are available to discover such information regarding the Panamanian company?
First, I consider important to mention that in Panama, a new insolvency law came into effect in 2017, which incorporates provisions dealing with cross-border insolvencies involving companies incorporated or doing business in Panama. So most of actions presented to the courts are first impression for the judges. To that effect, the insolvency laws seek to encourage cooperation between Panama and foreign jurisdictions and manage cross-border insolvencies efficiently for the benefit of the parties. Under the insolvency law, a foreign court or representative may request assistance from the Republic of Panama in relation to a foreign proceeding. Panamanian dispositions in cross-border insolvency allow a foreign court or a foreign representative to request assistance in relation to a foreign process. It allows a process being processed simultaneously and with respect to the same foreign debtor and insolvency proceedings in Panama. Also allows creditors or other interested persons who are in a foreign state and have an interest in requesting the opening of a process or in participating in a process in the Republic of Panama, which is being processed in accordance to the law, to this new law of insolvency. Assistance can be requested from insolvency law court to insolvency court without the need of recognition of the foreign process in the event that the Panamanian company has not been consolidated to the foreign insolvency or declared insolvent in the foreign proceeding. Also, dispositions state that cooperation and direct communication between the courts of Panama and the courts of foreign representatives is possible, and the competent courts shall cooperate to the extent possible with foreign courts or representatives, either directly or through their insolvency representatives. Outside of the insolvency proceedings, also there are tools available to obtain information regarding Panamanian companies, mostly through precautory measures, mainly a discovery proceeding to secure evidence. One of the advantages of this type of precautory measures in Panamanian procedures is that it is adopted without the other party knowing such measures is being dictated. However, once dictated or practiced, it can be challenged by the party or by third parties that may be affected by this request. In order to obtain such precautory measures, the parties that made the request shall post a bond to cover for possible damages and losses that the measure may cause if granted without merit. The information to be requested must be very specific and determined with precision. When requesting this measurement, we need to request specific records and documents to be examined, and the information we're looking for also needs to be specific. The Panamanian courts will not allow the request for general information or the review of all books and records. So it is very important to know what you're looking for through maybe a private investigation or through other measures that you can do to find this information, and when requesting to the court, be very specific. And also the discovery measure shall be carried out by an order of a competent judicial authority, and it has to be authorized for that specific purpose. Another condition requires that the request shall be made by a legitimate party who has interest or responsibility in the matter, or issue for which the measurement is being requested. I have to say these measures have been accepted by circuit courts and the Supreme Court as well. Nevertheless, the circuit courts are very strict in checking all conditions are met, and sometimes their interpretation may be too strict or subjective, and they can deny just without a lot of explanation. So it's a measure that we have on hand, and it has been useful before, but there's no guarantee that you can get it. So it's tricky. Also regarding the corporate veil, we need to understand that in Panama, the corporate veil cannot be pierced unless specific criminal actions have been committed. But Panama is starting to accept this in foreign judgments. We can find judgments where the corporate veil was torn in the foreign insolvency procedure, and the Supreme Court agreed to notify such measure without considering this act as a violation of Panamanian public order. In other words, although tearing the corporate veil is not appropriate in Panamanian law, the Supreme Court has notified a process where the veil was torn according to foreign law. So the exception to enforce foreign insolvencies is that it violates public policy norms. But as we can see from the mentioned precedent, the court recognized the order to tear the corporate veil without considering it a violation of the public policy. We need to see if this it maintains during in other judgments. So it's an interesting point that is rather new for us.
That's very interesting. I'm sure we would like to know more about the piercing of the corporate veil in Panama. However, now we're moving on with Nyana, because the clues are pointing to her, and we have serious information showing that Willy Wonka was involved in a scheme to strip assets from the chocolate factory through a complex set of limited liability companies and offshore entities. It turns out that Willy Wonka is the ultimate beneficial owner of the Panamanian company that took title to the Colombian plantations without paying fair market value for them. I have a different view than Nyana of Willy Wonka, but oh well. What can the Chapter 7 trustee do in the US to hold Willy accountable and bring those valuable assets back into the state, Nyana?
Well, I'm sorry to tell you, but the trustee was right that Willy Wonka is definitely a shady dude. So there are a number of tools available to the trustee in Chapter 7. Those tools are provided both by our federal law, which is the Bankruptcy Code, and also by applicable state law, depending on where the bankruptcy is pending. But in this situation where we want to essentially unwind a transfer and also to hold an individual fraudster like that shady Willy guy, we want to hold him accountable individually, right? So we probably want a judgment against him and to be able to go after his personal assets. So for those two purposes, I'm going to focus on 3 measures that we have available. One is a fraudulent transfer claim. The second is alter ego claims. And the third are nominee claims. So with respect to fraudulent transfer claims under the US Bankruptcy Code, we have 2 flavors to go with the Willy Wonka analogy. The first flavor is where there is actual intent to hinder, delay, or defraud a creditor. So that tends to be very difficult to prove. I have so far in my career only had one case where the fraudster actually wrote an email saying, I intend to defraud these people. I'm going to do so in the following way. That's not real common, however. So it can be a little bit difficult to prove actual intent. And that's why the second flavor is what we call constructive fraud. So essentially the intent or the fraudulent purpose is presumed because the debtor received less than reasonably equivalent value for the transfer. So that's one prong of what must be proven to establish a constructive fraudulent transfer. But there's another prong, and the second prong is a little bit complicated, so I'm not going to go through the whole statutory analysis. There's sub-prongs of the prong, but it basically involves showing that the debtor was insolvent, or showing that he couldn't pay his bills as they came due, or showing that the transfer was to benefit an insider, right? So if Willy was essentially transferring the assets to himself, that's for the benefit of an insider. And so for fraudulent transfer claims, the trustee has a 2-year look back. So hopefully this all came to pass less than 2 years before the Chapter 7 began, or the the order admitting an involuntary bankruptcy began. The consequence of an avoided transaction is interesting, though. The consequence is that the trustee may recover the property transferred, which in this case would be a little bit complicated since we're talking about real property located in Colombia, right? At least for part of this. We could argue about whether there are LLCs and other types of properties that Willie might have, or that the company, the chocolate factory, had. But certainly that real property in Colombia, you know, most jurisdictions that I've ever studied in the world, they have some form of the local action rule. So it would be difficult for us to take a US judgment and domesticate it there. But the other consequence of avoiding a transaction in the US is that the trustee may recover the value of the property transferred from either the initial transferee of such transfer or a subsequent transferee. So even if the property was transferred multiple times, you could trace it to somebody who received it down the line, or to an entity for whose benefit such transfer was made, right? So if Willie was the owner of the Panamanian company that is now nominally the owner of the Colombian plantations, I could ask the judge for a judgment against Willy Wonka for the value that he received when he received those through a corporation. It's a little bit complicated. You may have to do both alter ego claims and fraudulent transfer in order to achieve this result, but it does tend to happen in these complex fraudulent schemes. There's an important defense, however, to a fraudulent transfer claims, and those defenses are available to transferees who pay value and who take in good faith. So Willie would have a hard time showing that he had good faith because he knows full well where the assets belong, and it doesn't seem that he paid good value. But if we're talking about a third party, you'd have to look at what they knew at the time of the transaction, whether they were a purchaser who paid in good faith. But so let's talk about the second type of claims that we have available. We also have alter ego claims. These would be governed by state law. So the test under Florida law, for example, to establish a claim for alter ego, and the purpose of an alter ego claim would be essentially to pierce the corporate veil and to hold Willie accountable for the debts of the debtor, right? The assets that he took from the debtor. The test has three parts under Florida law. It is slightly different in different states. So those distinctions can be very significant. But just by way of example, in Florida, you have to show that the shareholder dominated or controlled the corporation to such an extent that the corporation's independent existence was non-existent, and that the shareholders were in fact alter egos of the corporation. So that's the first prong. The second prong is that the corporate form must have been used fraudulently or for an improper purpose. And the third prong is that the fraudulent or improper use of the corporate form caused injury to the claimant, which here would be the bankruptcy estate. So that's the second kind of claim that we could use against Willie. And the third would be a nominee claim. I use that name. There are actually lots of names for this that turn up in American jurisprudence. But this type of claim basically seeks to establish that an asset belongs to the debtor or belongs to the bankruptcy estate, even though it's not formally owned by the debtor. So this could be a useful tool if we discover, for example, that the chocolate factory's assets found their way into LLCs that are owned not by Willie, but by Willie's sister, or by an Oompa Loompa who is a trusted friend of Willie's, or something like that. Judge Isikoff here in the Southern District of Florida, she recently had a case involving a nominee claim, which are kind of novel. There's not a lot of bankruptcy cases reported involving nominee claims. So it's important that Judge Isikoff concluded that in order to determine whether a person is a nominee, the court should consider three factors: the control that the debtor exercises over the nominee and its assets, right? So if those assets are in the name of a person or another company, control by the debtor, or here by Willie, would be very important. Any family relationship between the debtor and the corporate officers. And the third factor would be the use of corporate funds to pay the debtor's personal expenses. So this is where you usually see the smoking gun. is where the Oompa Loompa is actually paying the mortgage on Willie's house. So the trustee could use this kind of claim or a combination of avoidance actions, alter ego claims, and nominee claims to pursue assets of the debtor or to obtain and enforce a judgment against Willy Wonka himself. But as I said, it would be very important to make sure that we have a coordinated strategy that would be recognizable in the applicable jurisdictions where the property is actually located.
Very interesting options. The clues are pointing to Susana. Regarding the Colombian subsidiaries, would you recommend the trustee to pursue recognition of the US proceeding or to start a new procedure in Colombia?
Well, the short answer would be that with regards to the clawback action, it would be almost the same if you start a local insolvency or you try to obtain recognition. Just for that point, it will be almost the same because probably the clawback action is going to be pursued according to the Article 74 rules. However, there is a discussion that has not been yet a reasoning in Colombia is that if it's a recognition, would the substantial law applicable to clawback would be that of the principal proceeding. So would be in the clawback, the applicable law to the transaction would be the US law or the Colombian law. So depending on that issue, you may choose between recognition or filing a claim here. But in this case, the facts seem to point to a clawback under both laws. So with that regard, I believe that it would be the same to file local insolvency and begin the clawback action during that proceeding, or to obtain recognition and seek for the clawback after recognition. However, Nyana was mentioning, what if you can get a judgment in the US and obtain homologation in Colombia? So that is a proceeding done before the Supreme Court of Justice, and actually we do have that rule that Colombian courts have exclusive jurisdiction over real estate and rights over real estate. So the issue would be if the judgment that is going to be subject to homologation is a monetary judgment or is a judgment about the real estate. Probably if it's over the real estate itself, it won't be allowed to be granted the homologation in Colombia, but if it's a monetary judgment, maybe that could be done even without a local insolvency proceeding or cross-border insolvency proceeding. But there are other circumstances that must be taken into account before deciding whether to bring the Chapter 7 to Colombia or commence a local insolvency. So first, you would have to look if the Colombian subsidiary actually meets the standard to be admitted to a local insolvency proceeding. And I mentioned that it must have some liabilities in default for a minimum period of time. Also, you should ask whether there are local creditors interested in the proceeding. If they are mainly located abroad, in this case, if almost all the creditors are located in the US, it seems more efficient to manage the entire proceeding from the US Chapter 7. Or you should see if the Colombian subsidiary without the plantations actually has a going concern that needs to be preserved, or otherwise was just left as a nutshell and you're just pursuing the real estate. Then it doesn't seem to be relevant to have an insolvency proceeding in Colombia, because you can go through the clawback action with the recognition. So there are a lot of circumstances that could help to reach the appropriate decision for each case. assuming that the creditors are located in the US and the only asset or relevant asset in Colombia are the plantations, probably obtaining recognition would be enough to get that decision to claim back the real estate.
Thank you very much, Susana. Rosa, you spoke to us already about measures available under Mexican law to unwind fraudulent transactions. Would Mexican courts be able to recognize an order from US bankruptcy court in the holding company's Chapter 7 case, determining that these sales were fraudulent under the US bankruptcy code?
Very good question, Aimee. First, I'm not sure I said that I'm very pleased for the invitation for this panel. Being in this panel with all of you, it's a pleasure, and I'm very honored. Now, going back to the question, well, it depends. As I said before, there have already been cases where Chapter 7 proceedings have been recognized in Mexico. Mexico adopted the model law on cross-border insolvency since 2000. And the cases we've had are liquidation cases, and there was used after declared bankrupt in the US, and they had assets in Mexico. So this could happen. Now, if the judgment in the US, as was saying Susana, concerns execution in real estate, well, that wouldn't be executed by a Mexican court because it has to be a Mexican court, the one that enforces or executes a judgment on real estate. So it would have to be a judgment like the ones we talked about, a judgment of declaring bankruptcy, you know, a foreign proceeding that wants to be recognized in Mexico. Now, as I said before, it's easier if we do, if we try to track the assets, recover the assets using the Mexican bankruptcy proceeding and the model law, because the authority of the trustee is broader. However, if for any reason it is decided that we're not going to start a Mexican insolvency proceeding, or that we're not yet going to request recognition because we want to get some information before, it would be possible. Although it is not very common in Mexico, there are many provisions that would allow to obtain information. In fact, in our commercial code, there's a provision that says that if a debtor is in liquidation or bankruptcy, a request of general information and books and records may be obtained. If the debtor is not in liquidation or bankruptcy, well, then a specific request on the books and records may also be obtained. Also, the inspection of assets could also be requested, or the deposit of sizer of the books of records if there's fear, you know, that they're going to disappear. So in all these measures, I believe they could also be requested as a preventive measures during the insolvency proceeding in case it is decided that it is convenient, you know, to request the recognition of the foreign proceeding and to start a Mexican proceeding under Mexican law. The only issue which is different in the model law, the way it was adopted by Mexico, is if the debtor in the foreign proceeding has an establishment in Mexico, then our law makes it compulsory to start the Mexican insolvency proceeding. If that's not the case, then you just request recognition. It is much more straightforward. You don't need to start a Mexican insolvency proceeding in Mexico. Also, I don't know if I said it, but also outside of bankruptcy, as Susana said, we have a clawback, civil clawback action, which is called Acción Pauliana. And this not only unwinds transfers at undervalue or for no consideration, but also payments made by the debtor before the maturity date or waivers of payment. And well, what you would need to prove to use that action is that the creditor's claim originated before this transfer, and that the transfer caused or aggravated the insolvency of the debtor. If there was consideration, you would also need to prove bad faith, and by this, it would be understand that the debtor did this transfer knowing its liabilities exceed its assets. It hasn't been used much, but there are some legal precedents about this civil clawback action. And also there are very recent precedents also in cases lifting the corporate veil.
And Rosa, are there any cases where Mexican courts have cooperated with foreign courts in the administration of cross-border bankruptcy? And what did the cooperation look like?
Well, I only know of 2 cases. And as far as I know, they're both, it was an American main foreign proceeding from the US. In one of the cases, I believe it was an individual. It was an individual that had a domicile in the US, was declared bankrupt under Chapter 7 in the US, but also have assets in Mexico. And the other case, I think it was a corporation. And it was also a main foreign proceeding in the US. I mean, those are the 2 cases that I know of. And in both cases, the foreign proceeding was recognized.
Thank you. Pamela, while the Chilean subsidiary continues to be operational and has not been fraudulently transferred, what measures are available to preserve the status quo? Are there interim or precautionary measures available to the trustee under the Chilean law? You're muted.
We have precautionary measures. But first of all, I would like to point out that I hope that the client will follow our advice, and the foreign trustee in this case will not be recognized in Chile. And why? There's another reason linked to your question, which is that the powers that are granted to the Chilean trustee are broader, are a lot more efficient than those that are granted to a foreign representative, in this case, the foreign trustee that was appointed in the US. So there is a very special regulation in our law that even if the foreign trustee is recognized and a local proceeding is filed, they can change and revoke some of the powers that were granted to the foreign trustee. So imagine that. So coming back to the faculties or the what is included in our law. Of course, we have all the clawback actions. We are called acciones revocatorias concursales. We have the acción pauliana as well. And there are special crime actions that must to be filed in front of a criminal court regarding fraudulent transfer of assets. As well, the Chilean trustee has a lot of faculties in order to preserve the assets. In this case, we have decided that this company runs really well, so we need to do everything to check if we still have all the assets, how can we continue running the business so successfully. We talk about changing administration, and if we find out that some assets were transferred, okay, there are actions that we can file in order to recover those assets and put them back into our company. As well, it's important what some of my colleagues here were talking about, which is if we have a lot of faculties or not in order for piercing the corporate veil. That's an issue that has been under discussion because of the bank secrecy, what is more important. And in one of the recognitions of the foreign trustee that we had a few months ago, the foreign trustee requested because he's used to that in Chile to pierce the corporate veil, and they told him, you know what? Only a criminal judge can order a specific disclosure of banking information. So now it started like a whole kind of interesting issue, how rights of a foreign trustee or even of a Chilean trustee can be really effective if they cannot access to banking information, which is key. And especially because in some cases of liquidation, which is not this case, of course, they don't have all the accounting and books available, or they're kept in good condition according to the accounting rules. So that's the more important facts about measures that this local trustee will have in this case.
Thank you, Pamela. One final question for Marlyn. In reviewing the chocolate factory's financial transaction, the trustee has been able to trace the proceeds of the over-invoicing into a Panamanian bank account held in the name of an entity controlled by Willy Wonka himself. Nyana, I'm seeing your face. What measures are available under Panamanian law to recover the proceeds of such misconduct? Would the Panamanian courts recognize and enforce an order from the Chapter 7 case avoiding this transfer?
The recognition of foreign insolvency proceedings is easier under the new insolvency law. Firstly, this recognition does not have to be requested from the fourth chamber of the Supreme Court of Justice, rather is requested from a lower and less formalistic court. Secondly, the new insolvency law expressly mentions that the representatives of a foreign insolvency proceedings are not only entitled to request in Panama the recognition and enforcement of foreign decisions declaring an insolvency, they can also request the opening of a reorganization or liquidation proceedings in Panama. And finally, within the recognition proceedings, the court can issue interim measures to protect the insolvent parties' assets. Under the new insolvency law, once the liquidation of a company is declared, any creditor can request the seizure or attachment of the assets of the directors, legal representatives, managers, agents, or auditors of the insolvent company, or any person that might have committed negligent or fraudulent acts against the creditors of the company. Attaching or seizing assets in Panama is a precautionary measure decided ex parte that aims to ensure the results of a judicial proceeding. For an attachment to be granted, the creditor does not have to provide prima facie evidence of their claim. They are only required to post a security bond in the form of cash bonds of the Republic of Panama, bank or insurance guarantees. The amount usually ranges from 30 to 40% of the requested amount to be seized. And after posting the security bond, the court will proceed to grant the request for seizure. And if a final judgment is rendered in favor of the defendant, it can request the amount of the bond as payment of damages suffered as a result of that attachment. So if the defendant does not claim damages after 3 months following that issuance, there's a final and binding decision rejecting the claim, and the bond will be returned to the creditor. So it's rather costly to present this measure, but it is effective if you have merits for the case. And we consider that the possibility of attaching assets of these persons also represent a major advantage for unsecured creditors who can use this interim measure as a way to prevent the potential liable parties from diluting their assets. So we believe this insolvency law measures increases the likelihood that unsecured creditors will collect.
Thank you, Marlyn.
Now, Aimee, I have a question for you. Let's say that the chocolate factory, it turns out, has something in the Dominican Republic. What would you recommend that the trustee do with respect to that jurisdiction?
The Dominican Republic has adopted the ancestral model law on cross-border insolvency, so the trustee can take evidence to trace assets. The first thing I would recommend is investigating if the debtor has assets in the Dominican Republic, and if the debtor has assets, then the trustee should file a petition to the court in the Dominican Republic to either open a parallel proceeding or to request recognition of the foreign proceeding in the DR. When the trustee requests that to the court, it is very important that proves the urgency to suspend all enforcement measures and actions against the debtor's assets. And if there are assets here, that a local judicial administrator is appointed to preserve the assets. Thank you. And we have two questions from panelists. One from Timothy Brock. It's frequently said by the United Nations and others that modernizing insolvency laws and making asset recovery by creditors more efficient and predictable promotes economic development and increases foreign direct investment. Has this been a motivating factor in your jurisdictions in terms of law reform? If so, is there any empirical or anecdotal evidence that such law reforms had those impacts? Well, the reform in the Dominican Republic was triggered by the World Bank report that put the Dominican Republic in the position number 160 in bankruptcy out of 190 countries. So, I mean, we're not that bad. So we enacted a new law following the model law, and I believe we're now like the 103 country. So at least it's something. Is there any anecdotal evidence of any other jurisdiction?
I don't have an empirical evidence, but I could say that our law, our current insolvency law that is from 2000, I think it did help a lot to build credibility, because the law we had before, debtors used to use it a lot to just suspend payments, and it would take for years, in order for them to be declared bankrupt. So this new law gives the parties only maximum 1 year to try to negotiate an agreement, an arrangement, and if they do not reach the agreement, an arrangement or reorganization plan within that year, then the judge has to declare the debtor bankrupt, and a trustee would be appointed. That would take the administration of the company. So I think even though we don't have many cases, it has helped a lot to, for creditors to feel more comfortable, that the procedure may help them, recover the assets or reach a reorganization plan.
Thank you, Rosa. The floor is open for questions, and for all that are in the panel, the chat will be available for 5 more minutes. So we can stay here responding to the questions, but if you can ask the questions now, it would be wonderful. The chat function is on the right-hand side of your screen.
I believe there's another question from Nancy Isaacson in the chat.
Oh, go ahead. I didn't see Nancy's question.
She said, in the countries where a petition for the foreign entity is recommended, who files the petition? The U.S. trustee? Is it considered an involuntary petition similar to the U.S.? In Mexico, yes, the U.S. trustee will have standing to file the petition directly before a Mexican court.
Well, in Colombia, the one that has standing to file the petition is the person or entity recognized as foreign representative of the proceeding. So sometimes when it is a Chapter 11, the debtor in possession itself could be recognized as the foreign representative of the Chapter 11, and that's the entity or person entitled to file the recognition petition. So there is no ex officio commencement of a recognition proceeding. The standing is limited to that person. But I'm not sure if the U.S. trustee is always the representative of the proceeding, probably in the Chapter 7 proceedings where there is a trustee appointed. But in the Chapter 11 could be the debtor in possession itself.
How about in Chile, Pamela?
Well, in Chile, it's the foreign trustee who files, but must be represented by a Chilean attorney. That provides a lot of work to us, but it's in the law that they must be represented by an attorney, like duly appointed with all their formalities, and should be an attorney registered with the Chilean bar.
Okay.
For Panama, it's also the foreign representative. The foreign representative needs to be credited on the foreign court. So an order has to come from the foreign court to be able to show that that's the person that can do it.
Thank you very much. We have no more questions. So we thank you for joining us in this treasure hunt, in which clues were given for a successful bankruptcy case initiated in the US and with proceedings in Mexico, Colombia, Chile, Panama, and the Dominican Republic. Thank you.
Thank you, everyone.
Thank you.